morning, everyone. What is dominating the news these days is SNC Lavalin. What is less in the news these days, and I'm not sure if this is just because SNC Lavalin is in and of itself complicated, but what's less in the news is the changes the Liberals made last year in 2018 to the criminal code to allow this to be happening. So what they did is they changed, and we're going to look in depth at it, but essentially they changed the criminal code to say if a corporation breaks the law, they can come forward and say, yeah, we broke the law, pay a fine, and then continue doing business as usual instead of having to go to court and having to deal with being prevented from bidding on government contracts for 10 years. Because if you go to court and you get found guilty of the crimes that they've now made into basically misdemeanors because you can pay your way out of them, if you're found guilty, you get removed from being able to bid for government contracts. So that's what they're trying to protect. They're trying to protect their shareholders' money, because if they get removed from government contracts, their shares will drop because they've got a decade of no work, right? Essentially, I don't know if that liquidates the company, but it prevents a major money faucet from being open to them, right? So it's a very complicated situation. And the reason it's a complicated situation is because the government just made this change. It didn't even come into effect. They actually had to postpone the SNC Lavalin case in order to access the changed legislation. They said, oh, yeah, no problem. We'll kick it down the line for a little bit in order to take advantage of the legislative change that's coming in. We'll look at that article too. But first, we're going to look at what the Conservatives said, because yesterday I was talking about why no strong language from Andrew Scheer. I'm going to double down on that. Why no strong language from Andrew Scheer? I looked for remediation agreement in his Twitter feed. We're going to look at that. I've looked for deferred prosecution agreement. They could be called, this tool could be called either of those things. Nothing. And in his letter yesterday, he calls and implores the Prime Minister to waive solicitor-client privilege and allow Ms. Wilson-Raybould to talk about what happened, right? And that's going to just get ignored. It's going to get tossed in the trash because these Liberals don't care. Do you know how much they don't care? Well, we're going to listen to the new Attorney General tell us that everything's fine. There wasn't anything wrong. How does he know there wasn't anything wrong? Because Justin Trudeau said publicly that there was nothing wrong. That's how. That's it. So, but my question remains, where's the strong language from Scheer? Bernier said unequivocally, I will absolutely repeal this ridiculous change to the criminal code and equal law for everyone, including corporations. And yeah, sorry, shareholders, don't let your corporations break the law. Like, if corporations are breaking the law and you're gleefully giving them money, sorry, you should lose money. That's it. That's a consequence to your illegal action, right? That's simple. So the bleeding heart game that these people are trying to play is incredible. Okay, and we're going to look at it from top to bottom. We are going to look at a Conservative MP and his stance on this, because we're going to open up what this bill is and what they changed and how they changed it and how they're taking advantage of it, because they are taking advantage of it. Make no mistake. It looks like Justin Trudeau put his nose in where it should not have gone, and it looks like he got caught. And this is big. Okay, first, these Liberals are closing ranks, though. Yeah, it's pretty crazy. Here we go. This is the new Attorney General, Lametti.
How can you say with any degree of certainty that there was no pressure put on her if you don't know? Who told you there was no pressure?
The Prime Minister has said publicly, and I'm basing. The Prime Minister said that that the allegations contained in the Globe and Mail article were false. The Prime Minister has said that he did not direct my predecessor, so I'm basing it on what he has said publicly.
Okay, but you're a Justice Minister. Is that what he said he didn't direct? Is he skating using legal language around the idea that there's pressure, that there's room? He may have pressured her in other ways, the Prime Minister's office. Are you 100% confident that there was no pressure in any way, shape, or form?
I can't speak to a relationship that I wasn't privy to. That's clear. But what I can repeat to you and to Canadians is what the Prime Minister has said.
So typical liberal talking points. I can't talk to that, but here's what I can say. And I mean, that was legalese as well, right? He's trying to fall back on, here's the Prime Minister's public statement. I'm the Attorney General. Of course, I believe the leader of the country, right? That's essentially what he's trying to put forward. So way back in May, here was Dan Albas talking about deferred prosecution agreements. This is when the changes were proposed and being debated in the House. And well, here's what was said. Mr. Albas says, quote, Mr. Chair, as I said prior to this and in all of our discussions on Division 20 in the bill, this is certainly not because of anything Ms. Shepherd has done. She's a fine public servant, and I appreciate her presence here. But again, this is the wrong body to be examining this. The Justice Committee could have called witnesses, academic, legal, and other concerned stakeholders groups to give this full scrutiny it deserves. What I find even more offensive in the amendment that has been put forward by Ms. O'Donnell is directly this. In a 5-year statutory required review, we are studying Canada's money laundering laws. We have yet to make any recommendations to the Government of Canada in regard to that. Here we are, a finance committee, putting such a serious economic crime as money laundering into a schedule that will apply and that will give the rough equivalent of a, quote, get out of jail card for those who agree to a deferred prosecution agreement. We have not studied Division 20 in depth. We have no witnesses, save Ms. Shepherd. In my view, we are not the body, despite the fact that we have some very distinguished members here. I hold them all in quite good stead that should be studying this departure from the criminal justice system. There's irony in our making recommendations on whether or not money laundering should be included as part of this new regime when we have yet to even conclude or even hear any evidence that this regime should be put in place for dealing with serious economic crime like money laundering. I would hope that government members would see that as being not a proper process. We are going to be traveling internationally to find out what other countries are doing, and here we are including that in a deferred prosecution agreement without having heard any single person beyond someone from the Department of Justice on the rationale as to why it should be included. Again, I hate to be the stick in the mud, Mr. Chair, but I guess I'll be the stick in the mud and say that this is the wrong body and this is the wrong time. If we were to make such a judgment, it should be after our including it in our money laundering review on the regime we have in Canada. And that's on May 23rd. Fast forward to June 20th, I believe, and I'll just figure out where we're supposed to be. Okay, so this is the Finance Committee meeting on June 20th, 2018. And I'll scroll down to where Mr. Albas, I think that's how you say his name, and I apologize if it's not, Albas, says, okay, thank you, Mr. Chair. Minister, you've recently made changes to the criminal code in regard to the money laundering regime we have here in Canada, and it was not the Minister of Justice who did that. Effectively, you've made it possible for big corporations to get a, quote, get out of jail card for money laundering. Why do you think that this makes Canadians safe? Bill Morneau says, perhaps you could provide more detail on how you've come to this conclusion. Dan Albas says, in Bill C-74, Division 20, you've made a change that includes a schedule in the criminal code that includes money laundering that gives effectively large corporations a get out of jail card. Do you not remember your own legislation? How is it that you see this gives an organization a get out of jail free card? That is what I'm trying to understand. A deferred prosecution agreement basically allows them to not actually have any consequences in a court of law for cases of proven, found money laundering. It's your legislation, Minister. How does that make Canadians safer? And I think there may be a fundamental misunderstanding on your part of what we're trying to achieve here, and then it's a lot of liberal doublespeak. And I guess I'll go through it because it's not that long. Quote, we recognize that when organizations are found to be offside with the laws, they should be held to account, and they should be held to account for their actions in a way that ensures we protect Canadians. That is what we're trying to achieve. We want to make sure that as we do that, we have a method that gets those organizations to pay the price of their criminality on their bad behavior, criminality or their bad behavior, and that it doesn't in any way negatively impact their employees or other unwitting people who happen to work in those organizations. Moving forward with the deferred prosecution agreement approach, an approach taken, as you probably know, by other countries, including the United States and the United Kingdom, as two good examples, we think it is prudent. It is a prudent way to ensure that we have companies pay the price for any wrongdoing in a way that allows us to ensure that our economy continues to be successful and that the people who are legitimately responsible for the bad behavior pay a price as opposed to people who aren't, such as people who are unwittingly employed by firms that have had their bad behavior. We think it's a good approach. And Dan Albas again, not allowing this legislation to be studied by the Justice Committee. Actually, the amendment was made at at clause-by-clause study, Minister, meant we didn't actually get to see the justification from your government on that. I'm very disappointed that you just simply can't explain why this measure makes Canadians safer. However, I'm going to go back to the line of questioning on beneficial ownership. You're working with the provinces. That's good to create a registry. Obviously, both the provincial governments and the federal government have access to that. Does that include CRA? Okay, so that was the end of the line of questioning on that. So we knew in June what was happening with the change in the criminal code. And there was a little bit of reporting on it, but it was really kind of quiet. Here's a CBC News article from May 15th. Okay, so May 15th, Mr. Albas, or earlier in May, sorry, Mr. Albas had the initial conversation, and then this news article came out. The NDP were also upset with this, and yet this bill passed. Okay. Federal budget bill quietly proposes tool to ease penalties for corporate crime. A federal proposal that would allow prosecutors to suspend criminal charges against companies in certain cases of corporate wrongdoing has been quietly included in the Trudeau government's 582-page budget legislation. In fact, its inclusion was so discreet, even one Liberal MP studying the legislation was caught by surprise. The government intends to move forward with an amendment to the criminal code to create an optional tool for prosecutors that's sometimes referred to as Deferred Prosecution agreement. Such agreements are designed to encourage more companies to come forward to self-report corporate crimes and to identify individuals for prosecution. If it lives up to its end of the bargain, the company as a whole would avoid facing serious criminal charges, which could include bribery, corruption, and insider trading. Oh, wouldn't that be nice if you could do bribery, corruption, and insider trading and then just say, oh, it was that guy, and then continue doing business as the company that you were working for before? Isn't that great? Wouldn't that be wonderful? Back to the article. The change, however, has raised concerns among lawmakers, including Liberals, on the House of Commons Financial Committee, which has been analyzing the broader budget bill. I scroll down a little bit. The explanation by Anne Shepard, a senior counsel in the criminal law policy section, prompted many questions from members who recommended the provision on the Deferred Prosecution agreement be removed from the legislation because it was such a significant change that they thought it warranted more thorough study. Liberal MP worried. That was weird and strange. Some also call for the provision to be studied by the House of Commons Justice Committee, which they argue has more expertise when it comes to changes to the criminal code. Liberal MP Greg Fergus told the committee last Tuesday's hearing that he was concerned that the changes appeared to be designed to give those implicated in white-collar crimes a, quote, little slap on the wrist. I do have some serious questions about this, said Fergus, who said that while he had read through most of the large budget bills before the committee hearing, he hadn't seen the Deferred Prosecution's provision. It seems we're letting those with the means have an easier time of it than those who don't have the means. In her explanation, Shepard described the regime as a new tool that would give prosecutors discretionary power to seek an agreement with the company accused of economic crimes when it's in the public interest. The charges against the firm would be stayed pending the successful completion of the agreement, she said. Or it would allow companies who can lobby the Prime Minister's office to make him then lobby his AG, and if the AG doesn't play ball, replace the AG, right? Oh, wait, is that speculation or is that proven yet? Not sure. Back to the article. The legislation lists 31 qualifying offenses, including bribery of a foreign public official, municipal corruption, fraud, theft, forgery, and insider trading. The government calls the proposed system the Remediation Agreement regime. Okay, so I looked at Andrew Scheer's Twitter. Here it is. The Remediation Agreement, nothing. Nothing at all. Nothing for Remediation Agreement. Why not? Why aren't you screaming about this? This would fire up your base. If you tweeted about this, Mr. Scheer, in May, I would have been all over this all summer, talking about what's going on and why SNC Lavalin was important. And we're going to look at why SNC Lavalin is important way back then, because there was reports in September. This is the end of summer, Mr. Scheer. Your silence impacted the news, sir. But first, we're going to look at the government of Canada remediation agreement in order to address corporate crime. I just want you to see this. This is real. Like, this is not parody. This is wallpaper over criminality, and they're trying to tell us that this is good for us. This is good for Canadians, guys. No. Just let Walmart get away with corporate crime. That's part of doing business. And then, you know what they do? They give us all this money when we catch them, or when they self-report their criminality, right? Because they're going to self-report what they're doing, because we're going to give them this incentives, because we're never going to prosecute them, because they're just going to give us money. Does that make any sense? So rich people can buy their way out of, corporations can buy their way out of prosecution, but You and I, no dice. And this isn't a 2-tiered legal system, 3-tiered now. You've got the political class, you've got the corporate government or the non-governmental organization class, and then you've got regular everyday Canadians. You better not drink once you get home because you might get arrested for drunk driving. Wild, right? Absolutely wild. This isn't parody. This is the bad laws being passed by the Trudeau government, okay? And seemingly silence from the official opposition. Remediation agreement. It was in the news in May. Where are you? So, what is the remediation agreement? Backgrounder. There were more than 370 Canadians, industry associations, business, NGOs, non-governmental organizations, and others participating in the public inquiry whether it should be done. And you can see the results of the consultation, and that's here. I don't have time to go through this. This is massive, and I just don't have time to go through this right now. But we're going to look at this. The remediation agreement and orders. A remediation agreement would be a voluntary agreement between a prosecutor and an organization accused of committing an offense. Agreements would set out an end date and would need to be presented to a judge for approval. Before approving a remediation agreement, the judge would need to be satisfied that the agreement is in the public interest and the terms of the agreement are fair, reasonable, and proportionate. Okay, so SNC Lavalin was bribing the government of Libya and basically stole $130 million from them. So is it in the public interest to just wallpaper over that and not give them anything more than a fine and let them continue bidding on Canadian government contracts? Yeah, we don't want to blot their record. Oh, and the 117 or 115 companies that are on the world corruption list, we don't want to blot their reputation, that SNC Lavalin, right? It's definitely in the public interest, right? And they're fair and reasonable, proportionate. The terms of the agreement are fair and reasonable and proportionate. Yeah, sure. What a farce. What an absolute farce. Okay, back to the Government of Canada's own website talking about this ridiculous agreement. When the criteria are met, the judge would issue a judicial order approving the remediation agreement. While the agreement is in force, any criminal prosecution for conduct that is covered by the agreement would be put on hold. If the accused organization complies with terms and conditions set out in the agreement, the prosecutor would apply to a judge for an order of successful completion when the agreement expires. The charges would then be stayed and no criminal conviction would result. If the accused did not comply, the charges would be revived and the accused could be prosecuted and potentially convicted. So they have to comply, otherwise they're going to go to court. Purposes of remediation agreement. The main purpose of a remediation agreement would be to denounce an organization's wrongdoing and the harms that such wrongdoing has caused to the victims or to the community, to hold the organization accountable for wrongdoing, to require the organization to put measures in place to correct the problem and prevent similar problems in the future, to reduce harm that a criminal conviction of an organization could have for the employees, shareholders, and other third parties who did not take part in the offense, and to help repair harm done to victims or to the community, including thorough reparations and restitution. Potential benefits of the remediation agreement. A remediation agreement would hold organizations accountable for their wrongdoing and would provide an incentive to rectify their wrongdoing while avoiding some of the negative consequences of criminal conviction. Oh, like 10 years prevented from bidding on government contracts? Like that negative consequence of illegal activity? It could help result in faster compensation of victims and protect jobs of innocent employees and investments of innocent shareholders. The possibility of being seen to negotiate a remediation agreement may also encourage corporations to disclose wrongdoing and cooperate more readily with investigators. Eligibility requirements. To be eligible for a remediation agreement, the accused would have to be an organization other than a public body, e.g. a government department, a trade union, or municipality. So trade unions can't get this, municipalities can't get this, and government departments can't get this. Only if you're a private company, you can access this. You can pay your way out of these things. Definitely money launder, bribe people, do it. If you get caught, you've got to give us money. And, the government doesn't want to get caught having to give the government their own money back, right? Wouldn't that be silly? A remediation agreement could only be used for economic crime offenses such as fraud or bribery. It could not be used for offenses that have caused death or serious bodily harm or that have injured national defense or national security. Similarly, a remediation agreement could not be used for an offense committed on the direction of or on behalf of a criminal organization or terrorist group. What happens when the actual company is a criminal organization or terrorist group? What happens then? Here's an article from September 10th, 2018, and it says, SNC Lavalin hearing pushed back until criminal code changes take effect. Yeah, thanks, Financial Post. The Court of Quebec has postponed and shortened the preliminary inquiry into SNC Lavalin Group Inc., which is now scheduled to kick off October 22nd following the activation of a new criminal code provision in the company's lawyer says will work in its favor. The court hearing, initially slated to begin Monday and run for 50 days, relates to criminal fraud charges against the Montreal-based engineering and construction giant. The provision, which comes into force later this month, enables deferred prosecution agreements. The so-called remediation agreement found in other G7 countries allow companies to settle corporate corruption cases and avoid being put at a disadvantage when competing against rival firms. That means they get to keep competing against rival firms, especially for Canadian government contracts. Here's Andrew Scheer looking for deferred prosecution agreement. When I looked for any of these words, the only one that came up was agreement. Weird, right? Where are you? So National Post, this is from today or yesterday. No, this is from a couple of days ago, but I wanted to fast forward a little bit. This has blown up spectacularly when the AG, Miss Wilson-Raybould, refused to play ball. And make no mistake here, I don't like her laws. Her C-45, C-46, appalling, absolutely terrible. Her assisted death laws, awful. Okay, I don't think she's a great lawmaker, but I think that this stinks. That good or bad, it doesn't matter at this point, right? I don't agree with the laws that she was passing fundamentally at all, but because they were bad laws. But that doesn't mean the Prime Minister didn't act inappropriately. That doesn't mean that he didn't put pressure on her and that she is now a victim. So they're different things. I'll gladly talk about the shortcomings in her work, but maligning somebody, saying she's, quote, hard to work with is very fundamentally different. And you don't shuffle somebody out of cabinet that way. It's really interesting to watch the different layers happening like in real time. It's kind of cool, but it's also weird and very disturbing. So, okay, I just wanted to make that clear though to people who maybe think I'm on the side of Miss Wilson-Raybould with the laws that she passed. I'm not. I think she was generally, I don't agree with them, but I think that the Liberals agree with them. I think that the Liberals look at those laws and think they're good, right? So it's an ideological difference. I think that they think that what she was doing was in line with what she was asked to do. Anyway, I'm getting off on a side, and I want to get back to SNC Lavalin because this video is longer than I thought already. Okay, Andrew Coyne, hard to overstate seriousness of SNC Lavalin allegations. Can it be? Can a large politically sensitive corporation with a history of buying influence avoid prosecution in this country by mere expediency of a phone call to the Prime Minister's office? Can the Prime Minister's staff have charges against the corporation dropped by a quick call to the Minister of Justice? Is that the sort of country we live in? It looks like it is, Mr. Coyne. After this week, we can guess how these questions would be answered in the Prime Minister's office, at least. Yes, of course. Indeed, long before it was reported on, officials in Justin Trudeau's office had pressured the former Minister of Justice and Attorney General of Canada, Jody Wilson-Raybould, to have prosecutors set aside criminal charges against SNC Lavalin, the giant Quebec engineering and construction firm. The government had gone to some trouble to provide the company with a softer option. Buried deep in the 2018 omnibus budget was a provision allowing corporations charged with certain offenses to avoid prosecution by signing so-called remediation agreements in place of convictions. Fines and jail times, the company and its executives are obliged, in essence, to admit they did it, put back the money, and promise to never do it again. The amendment was inserted in a strenuous campaign of public advertising and private lobbying, 14 meetings with officials in the Prime Minister's office alone by who? SNC Lavalin. Yep. The issue was of more than academic concern to the company, which has since 2015 been facing charges of bribing public officials in Libya in violation of federal anti-corruption legislation. But then the company was no stranger to scandal, foreign and domestic. Before that, from Padma Bridge project in Bangladesh to the Kerala hydroelectric dam in India to the McGill University Health Centre in Montreal to the 2016 compliant agreement with Elections Canada, in which it admitted funneling tens of thousands of dollars in illegal campaign donations through its employees over several years, almost all of them to the Liberal Party of Canada. You can imagine how attractive remediation would be in such cases. As an alternative to imprisonment, for managers, the risk of getting caught becomes no more than the cost of doing business. Heads, you get the contract. Tails, you, or rather shareholders, pay a fine. SNC Lavalin says the executives responsible have left the company, that its corporate culture has changed, but while it may no longer be in the business of breaking laws, it certainly appears to be in the business of drafting them. With the help of high-priced lobbyists telling sob stories to compliant politicians of the dire economic impact in a certain province if the company were held to account for its actions. Could it be Quebec? No! Back to the article. Alas for SNC Lavalin and the Liberals, even with the remediation provision in place, it remained up to the discretion of a nonpartisan prosecutor whether to make use of it. Last October, the Director of Public Prosecutions, Kathleen Russell, refused. Officials from the PMO then reportedly put Wilson-Raybould under heavy pressure to intervene with Russell. She reportedly refused. A couple of months later, she was then busted to Veterans Affairs. The truth of these allegations is suggested not only by Wilson-Raybould's repeated on-the-record non-denials. The solicitor-client privilege she has invoked may forbid her to confirm incriminating statements by her former clients in government, but not to deny them. But by the Prime Minister's own repeated non-denial denials, carefully refuting allegations he did not direct her to intervene that had not been made. There remains a number of unanswered questions to be sure. If Wilson-Raybould was pressured to do something so obviously improper, why is she still in cabinet? On the other hand, why wouldn't she resign in protest? On the other, why would the PM risk firing her knowing what she knew? And why would she accept such treatment? But the scandal here does not lie in its aftermath, but with the original alleged interference. It is hard to overstate how serious a matter this is. It would be bad enough for Wilson-Raybould to have instructed prosecutors on her own, at least without putting her reasons in writing and notifying the public as the law requires. It would be many times worse for the Prime Minister or his staff to have pressured her to do so for any reason, let alone on behalf of a firm whose illegal campaign donations their party had only recently had to return. Prosecutors are supposed to be insulated from political interference for a reason. Put it this way, suppose instead of leaning on the minister to go easy on a friend, the Prime Minister's people had wanted her to go after an enemy. At the very least, for the PMO to have intervened in the way alleged would display appalling judgment. At the worst, it may count as obstruction of justice. The former Liberal Attorney General of Ontario, Michelle Bryant, and former Judge Mary Ellen Turpel-Lafond are among those who believe a crime may have been committed. Certainly, it calls into doubt the government's protestations in the controversy over the extradition of Huawei executive Meng Wanzhou. It's about its devotion to the rule of law. It also possibly sheds new light on the murky dealings surrounding the dismissal and prosecution of Vice Admiral Mark Norman for allegedly leaking cabinet secrets. The worst part is, it is not clear what can be done even if the worst suspicions prove true. The RCMP, embarrassingly for an alleged mature democracy, have had a decidedly spotty record investigating allegations of wrongdoing by their political masters. Neither has Parliament proved particularly effective in past scandals at getting to the bottom of something the government of the day wishes to be suppressed. Those in power seem to have drawn the appropriate conclusions. Will the pattern be repeated? We're about to find out if this is really a country governed by the rule of law at all. And I agree with Mr. Coyne on this one. Essentially, it looks like the Liberals changed the law to help their friend, and then changed the Attorney General to help their friend when their current Attorney General wouldn't. But it does beg the question why she's still part of a Liberal cabinet and not crossing the floor if what's alleged is even close to true. If there was an email or anything, I would be crossing the floor. But again, I'm not Miss Wilson-Raybould. I don't know what she knows. So, but I'm shocked that more Liberals aren't crossing the floor. Like the level of corruption and the level of lack of caring, the lack of caring that these Liberals seem to show towards Canadians, the disdain to which they show towards Canadians is incredible. It's on full display. My goodness, it's appalling. So that's SNC Lavalin in a nutshell. Thanks for watching. Thanks for sticking with me. I realize this is a much longer video than usual, but there we are. That's it. Have a wonderful day. Check out thepeoplespartyofcanada.ca. Thanks.